Yes, Mr. Court, I'm now moving on to the last point that I'm going to deal with in relation to desire to prefer, and then moving to balance sheet and solvency. I'm not expecting to take very long over that, so my anticipation is that I will be finishing by about 3 o'clock.
3 o'clock, okay.
The last point in relation to desire to prefer concerns my cross-examination of Mr. Enoch, and the court has seen the submission made in the appellant's skeleton argument of paragraph 41 that I didn't put to Mr. Enoch the suggestion that he had the relevant mental state.
Yeah.
And originally that was sought to be run as a point in aid of a serious procedural irregularity challenge, but as you now see, it is a point that only goes to the weight the judge might have given to that denial if it had been made. Our skeleton argument proceeded on the basis that Darty were correct in saying that I omitted to challenge Mr. Enoch directly about desire to prefer. I do want to show you a couple of pages in it which are relevant to that. The transcript of his cross-examination is in the supplemental bundle, volume 2, tab 34. And the first material passage is on bundle page 531. If you have bundle page 531, you see on the top left quadrant in line 8 that I'm putting to Mr. Enoch a document which is quite an early presentation by Lazards, who were advising Keyser back in October 2010. And if you look in the bottom left quadrant, transcript page 46, you can see that there was a little menu of options which Lazards proposed to Keyser. 1, 2, 3, 4, 5, and then at the top of transcript page 47, the last of them, option 6, was administration or liquidation. And just while we're there, as we go past, on transcript page 47, line 21, I asked this question. Option 6, administration or liquidation, that wasn't a runner, was it? No, we didn't particularly think it was a good one. It is an option, but not the ideal one. And then over the page, bundle page 532, bottom left quadrant, transcript page 50, looking at line 5, I'm focusing on that 6th alternative, the administration or liquidation alternative, and I quote the Lazards paper saying, additionally, keys are likely to be required to write off intercompany loans of £20 million. So one of the disadvantages to pursuing a formal insolvency strategy was said to be the likelihood of having to write off. And then transcript page 50, line 21. So at this point, there's quite a limited appetite for Comet going into an insolvency process on Keyser's watch. Is that correct? Yes, that's correct. And on transcript page 51. And one of the reasons that we see reflected in this document was a concern on the part of Keyser to avoid a situation in which Comet's debts to the group treasury company would become irrecoverable. Do you accept that? And there you have the answer. We don't need to get into the answer. So I did suggest to him that at this point there was a concern on the part of Keyser about the possibility of having to write off or lose the intercompany receivable owed to Kill in the event of an insolvency process. And Mr. Enoch in his answer initially doesn't engage with that, but the answer doesn't really matter. And then the other passage I wanted to show you, you find if you turn on to bundle page 544, and within that, if you look at the top right quadrant, transcript page 99, the document I'm putting to Mr. Enoch here is the document that I showed you this morning. This is the Project Keel Op Capita Proposed Solutions document. This is the one that talks about Comet acting as the transitional buying agent to alleviate the concerns of the credit insurers. And just while we're there at 99, just note lines 7 through 11, one of only 8 contemporaneous documents in the trial bundle from the 5-week period between the first and second round bids. Turning over to page 545, bundle page 545, picking it up at line 7, this is me speaking, this is my question. So it's clear, isn't it, Whoever drafted this paper was at the very lowest attuned to the possibility that a bankruptcy of Comet post-sale was a possibility. Do you accept that? I accept that's what the paper says. Do you accept that since this was in your Dropbox, and it was a paper you will have seen at the time, it's a point to which your mind will also have been directed? Answer, it's probably one of thousands of papers. So one of the reasons that paper actually survived was because it wasn't on the email system that had the deletions. It was actually a private email, private Dropbox account of Mr. Enoch's. And so that led to that direct question in relation to him about what was in his mind. So in light of those passages, I accept that I didn't say in terms to Mr. Enoch, did you have the statutory desire to prefer? But I suggest it is a little unreal to suggest that the outcome of the trial might have been different if the question had been framed in terms more closely mirroring the statutory provision. I've already made the point that neither of Mr. Enoch's two witness statements gave direct evidence about his state of mind in relation to the kill repayment, not least because, as you've seen, his evidence was that it was something which had been driven by McFarlane's and op capita. And having rejected his evidence on that point, among others besides, the judge's overall assessment of Mr. Enoch was adverse. And so against that background, I submit that it is fanciful to suggest that her views might have altered had I put the question to Mr. Enoch in the more direct form that I understand is being suggested. I've also made the point in the skeleton argument that the obligation is, in any event, an obligation to controvert statements that are actually made in a witness statement.
Is that right? I mean, there is that obligation. Is there not an overlapping obligation to put your case to someone with relevant knowledge?
Well, part of the answer to that may be that in this case we had the benefit of presumption, statutory presumption. So the position was that Mr. Enoch, in a situation where we had put in issue in our pleading the point that the decision was taken as at the date of SPA, had not in fact volunteered evidence about his own subjective state of mind.
And just to be clear, you didn't have the benefit of any presumption as to when the decision was made.
True.
Yeah.
This is desire to prefer.
Yeah.
And there we did.
So if the decision was made on or about the 9th of November, the presumption works in your favour.
Yes.
If, on the other hand, the decision was made on the 3rd of February, the presumption still works, but it's been rebutted.
Yes. Which we accept. Acceptable. I'm moving on to balance sheet insolvency. The original primary submission in relation to this was that the learned judge had applied the wrong test in her reasoning below. And that was not developed to any great extent in the course of my learned friend's oral submissions yesterday afternoon. But I am nevertheless going to start with a brief summary of what we say the relevant principles are, not least because it is relevant to the point which Mr. Smith still makes in relation to the way in which the learned judge assessed the kill RCF. Now, given time constraints and given that the three appellate authorities, so Eurosale and the Supreme Court, and then my Lord Justice Lewison's two decisions in Bookie and Carton and Rococo, are familiar territory for the court with, I hope without intending any discourtesy to your ladyship, what I'm proposing to do
Don't worry.
is to summarise the principles that we say you get out of that, give you the relevant paragraph references, rather than taking up the court's time in an extended reading of any of that. And I'm going to do that in a series of 8 propositions. First, the concept of balance sheet insolvency picks up where the concept of cash flow insolvency leaves off. Cash flow insolvency is concerned with whether the debtor is currently unable to pay his debts or will become so in the reasonably near future. Balance sheet insolvency is concerned with the longer term, and it operates to prevent debtors, in effect, paying today's creditors in full at the expense of tomorrow's creditors. That's Eurosale paras 37 and 41. Second point, the first of two questions the court has to address in considering whether a case of balance sheet insolvency is made out is whether the value of the company's assets is less than the amount of its liabilities as at the relevant date. Call that a net asset deficiency. We've called it a NAD in our skeleton argument. That follows from the express wording of subsection 123 sub 2 itself, and it is ultimately a hard-edged question in the sense that it only admits of a yes or no answer, although it may, of course, entail judgment calls as to individual value components in the calculation. Third point, as Lord Walker pointed out in paragraph 1 of Eurosale, the concept of balance sheet insolvency in the Insolvency Act is not specifically tied to the provisions of parts 15 to 16 of the Companies Act concerning the preparation of financial statements of audit, but it does not follow that in assessing whether a NAD is present in any given case, the court simply ignores the audited accounts. They are the starting point for analysis, and they were treated as such in Eurosale by both the Court of Appeal and the Supreme Court, see paras 45 and 49. Fourth, it does, however, follow from Lord Walker's point that for the purposes of assessing whether a NAD is present, it may be appropriate to bring in liabilities or assets which would not be accounted for in the balance sheet on ordinary accounting principles. And as my Lord Justice Lewison himself pointed out in Rococo at paragraph 20, if you study the facts of Eurosale, the court in fact there augmented the company's gross asset position by reference to a claim it had in the Lehman insolvencies, which was not reflected in the balance sheet. Fifth,
What was the paragraph in Eurosale for your fourth proposition?
I didn't give you the paragraph in Eurosale. It was paragraph 20 in your Lordship's decision in Rococo, and I think that will give the reference back to Eurosale if that's acceptable. Fifth point, in determining whether a net asset deficiency is present, the court brings into account contingent and prospective liabilities appropriately discounted, Eurosale paragraph 41, but it leaves out of account contingent assets, Rococo paragraph 19. Sixth, if, having done all that, the court arrives at the conclusion that a NAD is, in fact, made out, as at, say, today's date, then the statutory deeming is engaged. As my lady observed during the course of argument yesterday, subsection 1232 is in for a deeming provision, but it is rebuttable. Since balance sheet insolvency is concerned with predicting a future inability to pay debts, but contingent assets, most obviously profits, don't come into the calculation at the first stage, a commercial question arises, which is this: is it likely that the net asset deficiency will be reversed out in future, such that although there may be a NAD today, the company can nevertheless be expected to be able to pay its debts when they actually fall due going forwards? That's Eurosale paragraph 49, and that's the question the court asks, which is effectively whether the presumption has been rebutted, the deeming has been rebutted. Seventh point, on its facts, Eurosale posed that question in an unusually schematic form, because the relevant company there was a closed investment vehicle which was not actively trading and whose only relevant liability was a note repayment due in 2045. And the basis for the actual decision that it was not insolvent, despite the fact that it had a net asset deficiency at the material date, was that the market variables were such that the court could not be confident that there would still be a net asset deficiency come 2045 when the debts fell due. So Eurosale exemplifies the important point that a finding of a net asset deficiency is a necessary condition for a finding of balance sheet insolvency, but it is not a sufficient condition. But eighth and finally, most cases will concern companies, as this one does, that are actively trading, generating cash, and incurring liabilities falling due at many different dates. And where that is so, what I've described as the second question will turn on whether the court believes that the NAD as at today's date will be reversed out in the foreseeable future. That's Bookie and Carmen at paragraph 38, most obviously by profitable trading. So that's what we say that the correct approach to the problem is. And the fundamental criticism made in my learned friend's skeleton arguments was that the judge below treated the question of whether or not there was a net asset deficiency as not simply a necessary but a sufficient condition, and failed to engage at all with the second stage question, despite there being a NAD, was it likely that Comet would fail to pay its debts as and when they fell due in the future? And we say that that is plainly wrong. If you go to the judgment in tab 6, I'll skip over the section in which she summarized, she went to all three of the appellate cases that I've just endeavoured to summarize for the court. And she specifically made the point that ultimately there was a question of commercial judgment. So it would be surprising if the judge had in fact committed the error which the appellate skeleton argument suggests she made. On page
176 and 177.
Exactly.
Points, aren't they?
So 176, that's answering what I've referred to as the first question, is there a net asset deficiency present? And the answer to that question is yes. And the appellant skeleton argument stops short of referring to what you see over the page at paragraph 177, in which the judge is plainly going further from that and asking herself the second question, which is whether there is a realistic likelihood of that net asset deficiency as at the transaction date being reversed out. And you'll see that she relies, looking at the second line onwards of para 177, effectively on 3 points. 1, operating losses in the period leading up to the disposal. 2, Keyes's own increasingly negative assessment of the prospects for the business. And 3, the limited interest that there was from potential purchasers. That second point, Keyes's increasingly negative assessment of the prospects, that's referring back to the decision of the Keyes board when it published its half-yearly results in December 2011 to write off the deferred tax asset on the basis that future profits in Comet were, quote, unlikely. If I can just unpack the first point in a little bit more detail, where she refers to Comet's trend of operating losses in the period leading up to the disposal. The basis for that, you see, if you turn back to bundle page 142, and this question of future profit-making potential loomed large because until closing submissions, it was Darty's position that the balance sheet should include the deferred tax asset, and its inclusion was critically dependent upon future profit-making potential.
It's paragraph 142.
Precisely.
Paragraph, isn't it?
Exactly. And so Mr. Ellison says, Comet's profits are falling off a cliff, and as happens when you do fall off a cliff, you fall faster and faster. And just to give you the figures, so judgment paragraph 11, there was a £3.8 million loss in 2010. And by the way, the accounting reference date was April, so the transaction occurs during the currency of the 2012 financial year. So 2010 2010 a £3.8 million loss, 2011 £31.8 million loss, and in the financial year for 2012 the accounts were never formally signed because the auditors wouldn't sign off without a comfort letter which Op Capita declined to give. The profit figure isn't actually stated in the judgment, but the loss per those accounts was £95 million for 2012. And that's what drives the comment that you see there from Mr. Ellison about the comments falling off the cliff.
But I think Mr. Smith's attack in oral submissions at any rate concentrated rather more on whether there was a net asset deficiency at all, because he says the judge should have discounted or ignored, I think, in fact is where he got to, ignored the kill RCF on the ground that it wasn't ever going to be called in while Comet remained a member of the Keyser Group.
So let me now come to that. So originally, just before I do, I'll just mention it only for completeness. Originally, as you will recall, there were two limbs to this attack about failure to discount. One of them concerned the kill RCF. One of them concerned a little group of 6 liabilities long dated in the sense of due over 1 year, totaling roughly £85 million. That latter point, I think Mr. Smith accepts, falls away because in his words it doesn't shift the needle because he hasn't got permission on 2 of those 6. And the remaining 4 are only worth £18 million between them against a net asset deficiency calculated by Mr. Ellison and accepted by the judge of £51.6 million. So it turns on the kill RCF. And the first question is, what is that relevant to? What is the kill RCF relevant to? That is relevant to what I've described as the first question, whether there was a net asset deficiency at the point of the transaction such that Comet was deemed insolvent prima facie. The kill RCF was not relevant to what I've just described as the second question. Was the deeming rebutted because there was reason to suppose going forward from the transaction date that Comet would still be able to meet its liabilities despite that NAD? Because of course moving forward from the transaction date, the relevant credit line is the HAL RCF and not the kill RCF. And whatever points one makes about whether or not the kill RCF is or is not to be regarded as soft financing, because from a parent company with a keen desire not to see Comet go into insolvency, the same most emphatically does not apply in respect of the HAL lending. Judgment paragraph 224 refers to the fact that some US distressed debt investment specialists stood behind HAL. And as a matter of fact, one doesn't need to speculate about what the likelihood was of the HAL RCF being called in because you know the answer. It was called in 9 months after the transaction date. So focusing on the pre-transaction position, at first instance, Darty argued that in calculating the NAD, the kill RCF ought to be heavily discounted, although they never made it precisely clear what that discount should be, because it represented soft credit. But there are 2 insuperable problems with that suggestion. The first is that the original basis for it was that the kill RCF should be analogized to a contingent liability as discussed by Lord Walker in Eurosale and accordingly discounted. But the judge rejected that as a hopeless point, and Darty does not have permission to revive that point in this court. Second, and in any event, as we said in our skeleton argument, it is, we suggest, impossible to argue that the kill RCF should be discounted on the basis that it was soft credit. The question before Mrs. Justice Falk was whether there was a net asset deficiency at or immediately before the transaction, but it was an integral part of that transaction that the kill RCF be repaid, and that repayment is precisely what these proceedings are all about. In a world where Kill actually demanded repayment and got it, we say it is hopeless to suggest that Comet was not insolvent at that point in time, because that debt might not have been called in some counterfactual world in which the transaction had not taken place. Now, my Lord Justice Lewison put that point to Darty in the course of submissions yesterday, and my learned friend sought to diffuse it by submitting that the consequence of the transaction as a whole was that Comet's balance sheet position improved. But we submit that that cannot possibly be relevant either. The judge's finding was quite specifically that Comet was balance sheet insolvent at or immediately before the payment. It is completely irrelevant whether the effect of the wider transaction was that Comet's net asset position improved after it. It's a completely different point. It is simply no answer to a finding that Comet was balance sheet insolvent immediately before the preference was granted to say that the wider transaction of which it was a component part had positive effect on the net assets. And even if it did, I make the point that the judge pointed out in paragraph 179 of her judgment that there was still a net asset deficiency on the IFRS accounting basis, although it is fair to say that she did not need to reach a concluded view about whether Comet was insolvent after the event because of the conclusion she had arrived about the position beforehand. And there was a difficulty to the extent that the figures prepared on the alternative UK GAAP basis suggested solvency. But the judge's view, as you've seen, I'm not going to take you back to it, is that if pushed, the IFRS basis, which is the basis that disclosed an ad, was the relevant one. For the simple
But if you
reason
wanted to rely on that, would it not have to be a respondent's notice point?
I'm not relying on that. I'm not asking you to make a finding. I accept the judge didn't make that finding. All I'm seeking to do is to diffuse the suggestion that it's somehow relevant that the net asset position of the company was improved as the result of the transaction. Even if you accept that, and I accept that on the figures both on IFRS and on UK GAAP, they do improve. But on the IFRS basis, it's still insolvent. There's still a net asset deficiency. Those conclude the submissions I was going to make, unless there's anything else that the court specifically wants me to address them on.
Thank you very much.
I'm very grateful for your time.
Yes, Mr. Smith.
Thank you very much, my Lord. I'll adopt the same structure as I did in opening, as my learned friend did, so address the three grounds in turn. Firstly, then, ground one, which is essentially the date point, to use that terminology. As I submitted, that breaks down to two elements. The first is whether a decision was taken by Comet in November. In light of my learned friend's submissions, we maintain our submission. There simply isn't any evidence of any decision taken by Comet in November. One of the questions that arises out of my learned friend's submission, as the court put to my learned friend, is to ask oneself, well, what was the decision supposedly taken by Comet at November? And on that, in my submission, the court has been faced with something of a moving feast. My learned friend said yesterday that there was a commercial decision that Comet would repay. He said then there's a practical decision subject to defeasance in the event that the new board were to determine that they were simply going to reject the entire transaction. So we get a new variation where effectively there's a decision that's subject to a subsequent decision by the new board. And then he said that the old board has decided that Comet is going to pay subject to the new board ratifying. And then he accepted today that that obviously had to be subject to further conditions, such as shareholder approval. Now, in our submission, that problem my learned friend faces in his submission is symptomatic of the fact that this part of the case is simply divorced from reality and divorced from the evidence. There's no evidence that Comet took any of those decisions. Before I come back to that, I would also submit to your lordship and my ladyship that my learned friend, the way he sought to put it, doesn't actually reflect the liquidator's case, or indeed the case which the judge believes she was accepting. Because if you go, please, to the judgment and start at 238, paragraph 238, which is behind divider 6. The judge begins this section of her judgment by setting out in the third sentence of paragraph 238 what she understood the case to be. The liquidator's primary argument summarised at 111A above was that Comet's decision was in reality taken on or around 9th of November 2011 by KHLKP and on behalf of Comet Mr Enoch, and the new board simply gave effect to that decision. And if you go back to 111A, which is back on 135, and what the relevant part is really the final sentence of 111A. And it said there, the desire of KHP, KEP, Kill and Mr Enoch to achieve a better outcome influenced Comet's decision. The resolution passed by the new board simply giving effect to a decision which had already been taken on or around 9th of November 2011 by KHLKP and on behalf of Mr Enoch, as reflected in clauses 8.6 to 8.20 of the SPA. So the case that was effectively being put was that Comet had made a decision, it was said, by the approval through the entities, none of which in fact included Comet, of the SPA, and in particular those clauses of the SPA. And I showed you those clauses. We obviously have, you have our submission that those don't in any way support the existence of a decision by Comet to repay now. They're all forward-looking, and in any event, Comet wasn't a party to the SPA. What we have is, in our submission, now effectively a variation and an attempt to come up with a different way of articulating the case in light of the difficulties it faces. My Lord, in our submission, one has to look at the probabilities, and rather than such an ever more elaborate and conditional decision supposedly taken by Comet in November 2011, it's much more likely, and indeed overwhelmingly likely, that Comet only took a decision when it had to, namely at the point of completion.
Well, suppose that we were to agree with you.
Yes.
Is that of any moment, for the purposes of an appeal against a finding of fact, the fact that we might have come to a different conclusion than the judge,
yes,
is not a reason for overturning her factual finding?
Well, it is, because in my submission there simply isn't any evidence.
Well, that's a different point.
Yes, well, that's...
Simply to say it's more likely that A happened than B.
Oh, yes, no, I'm proceeding on the basis that my primary submission is that there just isn't any evidence to support her finding. But then if you're going on to look at the question, I mean, maybe the court just leaves it there, but what I'm submitting is there is no evidence to support what she said. Once you've got over that hurdle, you ask yourself, well, what actually does the probabilities suggest happened? Next stage of the analysis. Then it's much more likely we submit that Comet only took a decision when it had to. And that is what the board minutes and the SPA say. Now, on the no evidence point, I mean, ultimately we're in the position of just saying there is a negative, there's a void. Really, all you've got, so far as November is concerned, is the SPA itself. You have all my submissions on why that isn't evidence to support the judge's conclusion. So far as the oral evidence is concerned, this point was not put to Mr. Enoch. You've got 252 of the judgment, and well, you've got the transcript of Mr. Enoch's evidence. You've also got 252 of the judgment, page 164, first sentence. When the judge records there that it wasn't put to Mr. Enoch that he was acting for Comet on the 9th of November 2011, it's also the case it wasn't put to him that he made any decision.
Whether he was acting for Comet or not is a different question to whether he made a decision.
a relevant decision to
If I
repay.
made a decision, what decision?
Exactly. A relevant decision. He obviously made a decision to execute the SPA on behalf of the Keyser entity. It wasn't put to him. He made a relevant decision in relation to the repayment of the KIL RCF on behalf of Comet. My little friend accepted that it was not put to Mr. Enoch that he made a decision on behalf of Comet in November or at any other time. He accepted that. This morning, the point wasn't explored with Mr. Platt or Mr. Dark either. There's no evidence that a decision on behalf of Comet, even if it was made at that time, was communicated to anyone. And the question of communication also wasn't explored with the witnesses either. So, as I've submitted to your lordships, I'm not running these points as a procedural irregularity argument. I rely on them as an absence of evidence. There just is a void supporting my little friend's case and the judge's conclusions on this point. So that's the first issue, which in our submission is fatal and remains fatal in light of my little friend's submission. The second point is that the judge's conclusion that the 3rd of February 2012 board decision was not a relevant decision in our submission is unsustainable in light of the evidence which the court has seen. Just to get one point out of the way, my little friend said yesterday that the board meeting was a colourable device and a device to mask the fact that the real decision was taken by others. In my submission, that's not something that's open to him. There's never been an attack, as he accepted elsewhere, on the veracity of that board meeting or on the accuracy of the minutes and in particular of the decision-making process that they record. And that submission, we respectfully suggest, should not have been made. Now, the critical point, or one of the critical points on the 3rd of February 2012 board meeting is what the judge herself says in paragraph 256 of the judgment, page 164. Now, my little friend appeared to think paragraph 256 is helpful to him. In our submission, it is categorically unhelpful to him because what the judge finds in paragraph 256 is the new board was making a decision. Now, it's true that she refers to it as a binary decision whether to go ahead with the transaction or not, and that bound up within that is the question of repayment of the KIL RCF. But nonetheless, it is a decision they had to make, and if they had decided not to go ahead with the transaction, the KIL RCF wouldn't have been repaid. And therefore there was, on the judge's own findings in paragraph 256, proper decision that was made and that had the causative effect of leading to the repayment of the KIL RCF or not. And ultimately, my little friend's submissions don't deal with that point we suggest. The other point we would make in relation to this is that on the evidence, and there's nothing to the contrary in the judgment, and the judge made no finding on this, is that the supposed decision made by Mr. Enoch on behalf of Comet in November was uncommunicated. On the evidence, if he did make a decision, it was something that simply took place in his own mind. And if that's right, it's simply a thing writ in water. It had no effect. It wasn't communicated to anyone at all. It had no effect whatsoever on the new board when it came to 3rd of February 2012. And it obviously had no effect whatsoever on those advisors responsible for documenting the transaction, who were very concerned to make sure that the payment instruction letters and the completion agreement were all signed off on by the new board. It was those which we've seen, which led to McFarlane's making the relevant payments, which led to the repayment of the KIL RCF. Now, likewise, if my learned friend was right that the decision made in November 2011 was one that was subject to ratification by the board in February, or subject to defeasance by the new board in February, to use that terminology, then that's fatal, we'd suggest, to him as well, even if that decision had been communicated, because the relevant decision in those circumstances would be the ratification in February. And my learned friend referred to wills getting to Corf joinery, but in this circumstance, we respectfully suggest wills against Corf joinery is very relevant to us, because that makes clear that even if some sort of decision's been made at an earlier stage, the relevant decision is the one that has the operative effect when the company is at that point deciding to make the payment and therefore deciding which creditor to pay in preference to others. So we respectfully submit that even if you look at it that way, the case law is unhelpful to him on that point. There was perhaps just picking up a slightly more incidental point, but I'll just deal with it given my learned friend mentioned it. In relation to paragraph 241 of the judgment, my learned friend referred to this and referred in particular to the judge's comment on the interrelationship between clause 7.5 and clause 8. And she says, in practice, clause 7.5 would never operate, essentially because she was saying that I think the payment would be affected by clause 8. In our submission, that's not actually correct when you look at the SPA, because although it's perhaps a point of nuance, clause 7.5 and clause 8 are actually dealing with slightly different things. If I can just show you that, and it's perhaps easiest to pick it up. Firstly, if you go to 8.10 on page 300, behind divider 23. So if you, clause 8 is dealing with the pre-completion steps, and the relevant one in relation to tranche A, mirrored in relation to the other tranches, is 8.10. And what 8.10 is actually doing, if you read it carefully, is imposing a procuring obligation on the parent, firstly for the issuing of a demand for repayment, and the company agreeing to repay such amount. So there's two things that have to happen there. There has to be a demand and there has to be an agreement to repay. And then 7.5A, back a few pages, is dealing with the position at completion, and that is a procurement obligation on the purchaser at this point, actually to affect the payment itself. So one can argue this is angels dancing on a pinhead, but there is actually a distinction between the clauses, and they don't overlap in that way.
So you say, do you, that chronologically clause 8 comes before clause 7?
That's correct.
Because clause 8 is dealing with setting everything up, making the payment, and clause 7 deals with actually making the payment.
That's exactly right. That's exactly right. And all of this is, of course, happening very compressed period of time, but that is the chronology of events. So in our submission, the judge isn't in fact correct in paragraph 241. Now, just to pick up two other points. My learned friend, I think in response to the question my Lord Justice Lewison put to him, was suggesting at one point that there was a decision made by Comet in November, because at that point it chose which creditors to pay in preference to others. That effectively, what the decision was a choice as to who to pay in preference to other people. In our submission, even if that's the right way of analysing it, the new board at the 3rd of February still had to decide whether to carry that choice into effect, whether to continue with the transaction with the necessary consequence of making the payment to that particular creditor, Kill. So it doesn't, in our submission, affect the ultimate analysis as to when the decision was made, although it is one way of analysing what the decision actually was. And we wouldn't necessarily defer from that as part of the analysis. It doesn't ultimately alter the fact that it was the new board on the 3rd of February who made the operative decision. And then finally, on this point. My new friend then made some submissions in relation to MC Bacon. In our submission, one needs to take a little care with those submissions in relation to MC Bacon, because what they were concerned with, or what that part of MC Bacon was concerned with, was whether the desire influences the decision and what test you need for influence in those circumstances. Obviously, we're concerned with a different question here, which is not the linking of desire to the decision, but the question of identifying the relevant decision, which is a different question. Now, the other points in relation to the first ground concern the role of Mr. Enoch. There was a lot of submission from my learned friend about Mr. Enoch operating under a Comet hat, it was said. But ultimately, in our submission, you need to identify that he did something on behalf of Comet. You need to identify what it is. It said he did, in some sense, on behalf of Comet. Otherwise, it's just a meaningless expression. And the point about recusal in relation to the pension trust company is irrelevant unless you can point to something that Mr. Enoch was doing on behalf of Comet itself. And the conflict of interest point doesn't prove that Mr. Enoch was doing something on behalf of Comet at November. And again, we submit there's simply an absence of evidence that he was doing anything at all on behalf of Comet at November. Now, finally, in relation to clause 9.4 of the SPA, my learned friend made some submissions in relation to that. This is the provision that deals with the if you don't get compliance with Schedule 2. One of the things he said was that wasn't advanced to the judge below. And he's correct about that, but the reason is that that particular point which the judge made in 239 and 241 of her judgment about there not being a provision in the SPA to deal with the possibility of Comet not complying was essentially the judge's point. It was a point that appeared in her judgment. It wasn't, we've checked my learned friend's closing submissions, he didn't make that point.
I'm only going to say I'm pretty certain we did make that point in written opening.
Well, we checked. We've checked over the short judgment the written closing submissions, and that point wasn't made in the written closing submissions. So therefore, it wasn't a point we addressed. It was a point that the judge identified from the judgment. In our submission, she fell into error on that for the reasons we've submitted. So those are our submissions in relation to the first ground, and as the court knows, we say the appeal succeeds on that ground alone. So far as we need to get into the second ground, that's the question of the inference of desire to prefer. So far as the test is concerned for this court on appeal, in our submission, this case is very similar to the case considered at paragraph 47 of the Daytech case. Like Daytech, it's a case where we don't dispute the primary findings of fact. But we do, as in Daytech, dispute the inference which is drawn from those primary findings of fact. And as in Daytech, this is a case where that inference doesn't turn on any question of the cross-examination of the evidence. It wasn't explored in cross-examination of the witnesses. It's essentially a process of logical reasoning where the judge has sought to extrapolate from the findings she did make and come up with an inferential conclusion. And in our submission, as in Daytech, as described at paragraph 47, that conclusion is susceptible to review by this court. Now, we then turn to the question of substance. And
sorry, just before you
yes.
go on to the question of substance, you say it's open to review by this court.
Yes.
What's the test that we should apply?
Yes, just that the judge is wrong.
So if we were to disagree,
yes,
we don't have to go as far as saying it's not rationally supportable or she's overlooked evidence. Or...
In our submission, not. I mean, we would say it's essentially the same approach as was taken in paragraph 47 of Daytech, given the actual process of inferential reasoning that the judge carried out in this case.
And what do you say about the cases that seem to suggest, including at least two judgments of mine, that a Court of Appeal shouldn't interfere with inferential findings unless they are rationally insupportable or the judge has plainly overlooked evidence and all the other things that Henderson and Foxworth says.
Yes. I mean, my submission ultimately on that is I respectfully submit it's quite difficult to set out a universal rule, and it will depend on what is the nature of the inference which the judge has sought to draw in every case. What is the material he or she has relied on? Does it depend, and to what extent, on the judge's assessment of the witnesses? All of those sort of factors are going to come to bear. But in our submission, this is in some ways quite an easy case, because you have the three clear primary findings of fact which we don't dispute. And then in essence, it's a process of logical extrapolation. And we submit that the process of logic which the judge has followed is simply wrong, is illogical. And in that sort of question, we submit is entirely susceptible to review by this court. Now, as my Lord Justice Lewison observed earlier, and I'm going to come back to this point, the judge's reasoning in relation to desire to prefer is a little curious, because she looked at it from the perspective of Keyser and then sought to attribute that to Mr. Enoch. And I'm going to come back to that point in a moment. But the first question one has to ask is, what inference can properly be drawn from the fact that the transaction was structured as a repayment rather than the other options which the judge identified in paragraph 209 of the judgment, which, as she said, would have led to the same economic effect? So, in other words, what conclusion, what can you infer from the fact it was done that way rather than some other way? Now, my learned friend referred to a number of explanations. First of all, he referred to the credit insurer's presentation point. He said it was done that way so that it could be shown to the insurers that there was sufficient liquidity in Comet post-transaction. But in our submission, that doesn't support an inference that the reason why repayment was selected as the method of implementation was to prefer kill. That suggests it was done because that would put Comet in a better position post-transaction under the ownership of Op Capita. So that was something that actually would have been driven by the interests of the buyer, Comet post-transaction, rather than those of kill. Secondly, he said later in his submissions that it enabled Op Capita to have a secured debt owed by Comet rather than an unsecured debt. Now that is undoubtedly correct, but that was obviously to the benefit of Op Capita, not to kill. It's clearly a matter of complete indifference to kill whether Op Capita's debt in the structured post-transaction is secured or not. And then thirdly, he came to rest on the point that he said the repayment resulted in Kill receiving real money by way of repayment, and the debt not simply being waived, capitalised or assigned. Now, with respect to my little friend, that point makes no sense at all. The transaction, as the court knows, was one under which Keyser was to pay a gross dowry of £50 million to Op Capita, together with the additional amounts for the pensions, less the amount for the debt. The agreed net dowry was 36.8 million. And if you go to paragraph 209 of the judgment, page 155, you can see in 209 that the judge records that the agreed net dowry was 36.18 million, and that is the 50 million gross pensions adjustment less the amount for the debt. Now, in our submission, it's clear from the judge's own conclusions in 209 that if the debt hadn't been discharged by way of repayment, then it would simply have been dealt with by another means such as waiver, with Keyser still paying the agreed dowry of 36.18 million to Op Capita. And from Keyser's perspective, Kill's perspective, it makes no difference at all whether it took place that way or whether it took place through a repayment. ultimately it's going to be in the same position at the end of the day of handing over cash of 36.18 million and the debt having gone. And it just doesn't matter from their perspective. It may be a matter of great importance to Op Capita, who want to have their...
I don't quite follow that. I mean, if you owe me £1,000,
Yeah.
and I say to you, well, I'll pay you 100 for selling something. If you repay the 1,000 you owe me, I'm £900 better off than if I say I'll pay you the 100 and waive the debt. I'm much worse off. So if Kill gets repaid, it's whatever it is, 15 million.
No, because what they've agreed, as recorded in 209, is that there will be a net dowry. The agreed dowry is 36.18 million. So they've started off by saying that the gross dowry is going to be 50 million. They've added something additional on that because KISA has to pay more for the pensions. And then they've deducted on that an amount in return for the discharge of the debt. And that gets you your 36.18 million.
So you're saying that whichever way the cat is skinned, you're going to end up with 36 points.
Yes, exactly. That's the agreed dowry of 36.18 million, which takes into account the amount receivable for the discharge of the debt.
I mean, there could be a more complicated way in which this interacts, I suppose.
Yes.
In the sense that, as I think you're recognising, there could be a very real benefit to Op Capita
Yes.
in this being done this way.
Yes. Well, I do recognise that. Yes.
And that could mean that Op Capita would not have been willing to countenance one of these other structures without the terms being adjusted in some way in its favour.
Yes.
Such that in circumstances where KISA didn't want to have to pay out more than £36 million, they had to adopt a repayment of debt approach.
Yes.
Because that was the only way they were going to keep a deal on such favourable terms. So if they wanted to come out with a clean break
Yes.
and keep a deal on these favourable terms, they had to go for this structure.
Yes. But that wouldn't be a desire to prefer Kill, because that would be driven by a desire to prefer, well, not to prefer, a desire to benefit Op Capita, because it is the one benefiting from the repayment structure, presumably because it's able to put in its debt on a secured rather than an unsecured basis. That doesn't, if you run that through, and let's assume that's right for the sake of argument, in my submission you can't infer from that Mr. Enoch, in effect going along with that on this hypothesis, would be motivated, influenced by a desire to prefer Kill. That wouldn't be the reason why he would be deciding to go with the repayment option rather than the waiver or capitalisation option.
I mean, one difficulty with all this, as I think we've sort of touched on earlier, is I'm not sure that this was ever really explored. So we don't actually know, in terms of evidence, what the witnesses were saying about why this structure was chosen as opposed to another. I mean, the transcript I've read is Mr. Enoch's.
Yes. Mr.
Enoch has put to him, well, there were other ways of doing it, and he says, well, I suppose so.
Yeah.
I don't know that it's really explored why this method was adopted.
It wasn't. This is one of the problems, and as I adverted to earlier, there was in effect a late pivot in the case. They will say it was a consequence of us putting in the evidence from Mr. Clare, Mr. Dark, which we eventually got hold of, which made clear that they didn't have the requisite desire to prefer. That led to the pivot in opening submissions, where we all of a sudden get the very close focus on November rather than February. And frankly, that was not then carried through into the forensic examination at the trial in the way it should have been. Amongst other things, Mr. Enoch's witness statements didn't deal with this question because it only arose from the way that the case was put in opening submissions and as a result of those amendments, which you've seen coloured in purple. But your lordship's absolutely right. That's a point that goes heavily against my learned friend.
Just in terms of chronology, as I understand it, the formal re-amended reply or whatever comes in after Mr. Enoch has finished his evidence.
Well, that's probably right. So, I mean, there
the
would have been...
liquidator had flagged his position before that, and you'd had a debate in front of the judge over whether the liquidator should be allowed to run the case you now wanted to.
That's right. I mean, I'd objected in opening submissions to the case being opened, which I said was not the pleaded case, and then that resulted in the liquidator putting some draft amendments forwards, and your lordship's probably right that by the time those formally got accepted, that may well have been after Mr. Enoch had given his evidence. But that sort of explains why it was, why we got to where it was. But I mean, your lordship's absolutely right. But I mean, ultimately, there just is an absence of evidence on all of this, and that's a consequence of the way the liquidator ran the case. Now, just to deal with one other point, I mean, there was a slightly curious point my learned friend seemed to be running by reference to paragraph 47 of the judgment, page 121, again by reference to the 36.18 million figure. And I think he was suggesting that the true dowry was 36.18 million plus 115 million. And he said that gets you to 150 million or something like that. I mean, that's obviously wrong, because the 36.18 million is net of the sum which is payable for the discharge of the KIL RCF. It's the net position. And the only dowry, so far as KIL is concerned, is the 36.18. So that's a net position. That point is not right. So if I was desire to prefer, I mean, it's clear that that wasn't put to Mr. Enoch. If your lordship goes to our skeleton argument at paragraph 36, page 41, we make the point it wasn't only that it wasn't put, but also he wasn't cross-examined on the part of his statement where he didn't think KIL or Keith were getting a financial advantage. The other point I would just highlight is that, and you get this from the footnote, is that we did make this point in closing submissions. And what one might have expected is that where one makes this point in closing submissions, the other side then says to the judge, well, let's recall him and put some further questions to him. That's what one might expect. And indeed, one might think most judges would allow that.
So which bit of your skeleton are we looking at?
I'm sorry, paragraph 36, page 41. I'm sorry, my lord.
Yes.
So this was the point about whether the question of whether Mr. Enoch had a desire to prefer was put to him in cross-examination. In our submission, it wasn't. And not only that, he wasn't in fact cross-examined on the relevant part of his statement. But I also make the point we make in footnote 31, because we did flag this point in closing submissions at the trial. And in my submission, what one might have expected, and certainly it would have been open to the liquidator to do, would be to ask the judge to recall Mr. Enoch and put whatever further questions he wanted to at that point. And one might expect that most judges would accede to that, but that wasn't done deliberately, notwithstanding we'd flagged this point. So it's not only a failure to put at the earlier stage, it's in effect an election to proceed on the basis that they knew we were taking the point it hadn't been put. Now finally, there was just some mention of, sorry, not finally, but just to deal with one point at this stage. My friend mentioned the question of document deletion which is referred to in paragraph 62 and 63 of the judgment. What your lordships and my lady need to know about that is that in closing submissions at the trial, my learned friend made clear he wasn't asking for any inferences to be drawn from the absence of those documents. And if you go to supplemental volume 2, divider 38, pages 41 to 42, it's really page 42 of the transcript, page 650 of the bundle behind divider 38. it's lines 2 through to 17, and he makes clear to the judge he's not asking for any inference to be drawn. And he was really proceeding on a different footing, which was to say, well, the absence of documents harms us.
Sorry, which are we looking at?
We're looking at page 42 of the transcript.
Yeah.
So it really begins.
So the judge says that she can draw inferences.
So she says, if you go to line 4, I'm not drawing inferences simply from, documents not being there in nefarious circumstances because you're not making that point. And he agrees he's not making that point. No, absolutely not. It's rather that, it's a bit like George Bomper's case. He said you're effectively saying that this is more likely to harm Kisa than, and that's exactly the point. In a situation where the onus is on the respondent, what onus in particular is on the respondent? On his reduction in presumption. So the way he ran it was essentially to say, well, the absence of documents is not something that inferences should be drawn from, but actually, evidentially, it's something that, in his submission, was unhelpful to us in terms of the evidential record. Now, just a couple of other points on the facts. In my submission, my little friend made then 2 bad points on the facts. The first concerns paragraph 19 of the judgment. And the document you see in supplemental bundle 1 behind divider 14. And if you go to paragraph 19, page 114, he referred to this paragraph where the judge referred to the document indicating that op capita suggests, amongst other things, that Kisa acts as a buying agent for a transitional period, and then referred to the Kisa paper from August 2011, and that paper is behind divider 14 of supplemental bundle 1 at page 209. And then if you go to that, I think he sought to make some points then out of the cons for Kisa that were identified in that paper, including the first, Kisa becomes Comet's largely creditor, which in the event of possible further deterioration in Comet's performance, including possible bankruptcy, could leave Kisa with a significant cash loss. Now, the point about all of this is this is obviously dealing with a completely different potential debt that never, in fact, came into place. This is concerned with a proposal that was never in fact carried out, under which Kisa would act as a buying agent for Comet for a period of 2 years in essentially buying the white goods which Comet sold as Comet's agent. So what this is looking at is nothing to do with the kill RCF. It's essentially that debt that might arise from Kisa acting as buying agent for Comet. So it's entirely besides the point. The most you can get from this is that Kisa foresaw that there was a possibility of Comet going into insolvency under op capita's ownership, which is not in dispute. That's one of the findings of fact which the judge made. But it's not, to the extent my learned friend's suggesting that shows a concern about recovery of a debt owed by Kisa to op capita, it's entirely besides the point. It's a different debt that never came into existence. The other point I need to pick up on is in relation to 221 and 223 of the judgment. And my little friend referred to these paragraphs. 221 is page 157. And I indeed referred you to these in my submissions. In the second sentence, whether or not they formed the view that Comet was solvent at the point of disposal, they undoubtedly knew that there was a risk of an insolvency process. Now, in our submission, what the judge is clearly referring to there is the risk of an insolvency process whilst Comet is under the ownership of op capita, not whilst Comet is under the ownership of Kisa. And that's clear from 223, but also from the first sentence of 225. And one needs to take a little care, because my learned friend put the point as saying, well, the judge found that there was a risk, that Kisa knew there was a risk of an insolvency of Comet. true, but only in relation to the position under op capita's ownership, not in relation to the position under Keyser's ownership. Now, ultimately on this point, we say you have to look at the way in which the judge reasoned it. And if you look at the start of 220, as my learned friend, my Lord Justice Lewison observed, the way the judge approached this was to look at it from Keyser's perspective and then effectively extrapolate that to Mr. Enoch. Just looking at this matter from Keyser's perspective, as the judge did, the fact that Keyser chose a repayment, went along with a repayment methodology, rather than a recapitalisation or waiver methodology in relation to the discharge of the debt, can't possibly show that Comet had a desire to prefer kill in the event of an insolvent liquidation of Comet. I mean, it just doesn't follow. Looked at from Keyser's perspective, it was a point of indifference in my submission, and if it hadn't been dealt with by way of death, repayment, it would have been dealt with by way of waiver. And it's simply impossible to make the leap from Keyser's selection of the repayment method to a conclusion that Comet desired to prefer kill in the event of a liquidation of Comet. And that's ultimately the way that the reason why this reasoning simply falls down. So that's ground two. So if I was ground...
Well, the judge bridges that, doesn't she? On the basis that Mr. Enoch was wearing his Comet hat, because you submitted at one point, admittedly a pleading point, you said they hadn't pleaded that Comet had the necessary intention, and she says, well, that's not a problem because I found that Enoch was acting for both. I can't now find it. It's
it might be
253. 253 and 254. So you submit that the liquidator hadn't pleaded that Comet had the desire, and then she says she doesn't think that's a problem because Enoch had the desire.
Yes.
He was a director of Comet and effective general counsel. And
Yes.
Other members of the board were content for him to proceed as he did or exclude from the process.
Yes, and I'm not I'm not appealing on that pleading point in the sense.
No, follow. But
Yes.
that's her what she says, admittedly in the context of a pleading point.
Yes.
But that's how she links Keyser, Enoch, and Comet.
She does as a matter of pleading, if you like. But my point is that if you look at the substance of what she's deciding in 220, she's, as a matter of substance, a matter of evidence, she's looking at it from the perspective of Keyser, and she's seeking to infer that Keyser had the desire to improve Kill's position because it chose the repayment methodology rather than the waiver or capitalisation methodology. And in our submission, that just doesn't follow, because this was a point of indifference to Keyser, and Keyser, if it hadn't got rid of the debt by way of repayment, would have got rid of it by waiver or capitalisation, still paying over, still laying out the 36.18 million. And in our submission, the hole in the reasoning, ultimately, is you can't make the leap from, as a matter of substance, from Keyser either having chosen or gone along with the repayment of the debt to a desire to put Kill in a better position in the event of Comet's liquidation.
That's a different point. I mean, there are two strands here, I think. Your first strand is you can't infer that Keyser had a necessary desire to prefer. And I think the second point is, well, even if you could, that doesn't show that Comet had a necessary desire.
Yes. I mean, I'm focusing, I think, for these reply submissions on the first of those, but I do make the second point as well, very much so.
But at this stage of the argument, it would be the case that Mr. Enoch had made a decision on behalf of Comet in November.
I accept that, that's right.
So the link from Keyser to Mr. Enoch
Yes.
and Comet wouldn't be obviously a difficult one.
I think that must be right. If X hypothesise, you've reached the conclusion by this stage that Mr.
And
B.
that's what the judge is saying at 254,
Yeah.
I think.
Well, it may be, but I mean, I accept the point. If you're approaching ground two on the footing that Mr. Enoch has made a decision on behalf of Comet on the November 2011, the second strand you identified
we have to, don't we?
We do. Yes, no, I accept that. I do, and that's why I'm focusing on the first strand, and that's what the judge is dealing with in 220, which is before you get to the second strand, she has to infer, the way she approaches it, is to infer that Kisa had the desire to prefer because it chose the repayment methodology as opposed to the capitalisation or waiver. And in my submission, that's the hole in the reasoning, because it simply doesn't follow from the fact that Kisa went along with chose the repayment, that was influenced by a desire to prefer kill. I mean, you have my submission that that would have gone in a different way. Then ground three I can deal with very briefly. I mean, ultimately our point in relation to this is that there is a tension in the judge's reasoning, because if you look at how she approached insolvency, she takes the kill RCF into account at full face value, notwithstanding in 289 of the judgment, as I showed you yesterday, she accepts that, quote, Kisa would not have permitted Comet to default on its debts under its ownership. So if one is just looking at the position on the footing that Kisa continues as owner of Comet, on that scenario, it can't possibly be said in my submission that Comet was balance sheet insolvent. The reality is Kisa would not have called in the debt. Now, the answer that's put to that is essentially to say, oh, well, that's right, but then this transaction took place and the debt was demanded as part of the transaction, and that shows that actually in the transaction scenario there was a demand made.
We're now looking at the date when the preference was given.
Exactly, so we're looking
at the 3rd of February.
We are, exactly.
Whenever the decision was made, we're now looking at the 3rd of February.
Exactly right.
And you have shown us the SPA.
Yes.
And you've made it very clear that clauses 7 and 8 are in reverse chronology, so to speak.
Yes.
So that by the time the payment comes to be made, which constitutes the preference, the demand for the kill RCF has been made.
It would have immediately prior to completion.
Yeah,
that's right.
So why is it wrong to take into account the kill RCF as a liability which by the time the payment is made has crystallised?
Quite, so look at it that way as well, which is the other way of looking at it. 2 points, it was then paid in full, it was fully discharged, so that you can't infer an insolvency from a failure to meet the demand on the kill RCF. And secondly, there is no finding that Comet came out of that transaction insolvent, and indeed the evidential position on that is that there's two balance sheets, an IFRS one and a GAAP one. The IFRS one shows a net deficiency, the GAAP one shows positive net assets. But the problem from my learned friend's perspective in my submission is that he doesn't have a finding that it was insolvent post-transaction, and if he'd wanted to pursue that point, we'd have had to have argued about the difference between the two balance sheets. We'd have said the right analysis is the GAAP balance sheet, not the IFRS one. So, I mean, if you look at it that way, the demand's paid and you're left with a solvent company as the output of the transaction. So we say you can't conclude pre-transaction insolvency on that basis either. If your Lordship will just bear with me 1 second. Subject to any questions from my Lord and my Lady, those are our submissions.
Well, thank you very much. Thank you both very much for your very interesting arguments. There's clearly something to think about here, so it will not surprise you to learn that we reserve our judgments. You will get a draft in the usual way. It comes with a fierce embargo, which means what it says, so it can only be distributed to those on the distribution list. That will be your opportunity to correct our English, but not our reasoning. And we would hope that in the light of the draft judgments, you will be able to agree an order disposing of the appeal. If you can't agree an order, please make short, and I mean short, submissions in writing on the form of order, and we will make the form of order that we consider to be appropriate.
Thank you.
Thank you all very much.
Can I just ask, would you like a copy of the hard copy of the transcript of today as well? We
I
provided
think
one of yesterday.
Oh yes, I
Yeah.
think that would be helpful.
Yes, we'll arrange for that.
Yeah. Thank you very much.